Okay. All right, let's see. So thank you guys for joining me today. We're going to be covering the North Carolina exclusive right to sell listing agreement. So one of the first things I wanted you guys to all have access to the NAR settlement resource page that the North Carolina Association of Realtors has released. It has a really great summary of every change that's been made to every North Carolina real estate document. And so the link for that is listed here. You can go through it. It even has links to all of the documents if you wanted to view the documents there too. So it's super helpful. So, one of the big changes to the listing and purchase agreements is that we are now, you guys are now going to be using co-op compensation agreements, and we're going to go over that in a second. So, this particular form was formerly titled Confirmation of Compensation Agency and Appointment, and it's been renamed, completely redrafted to help both agents navigating the MLS rules, code of ethics. And so this form is going to help facilitate a contract for cooperating compensation between the selling firm um, and the buy side. So if the listing and the seller, so if the listing firm and the seller have agreed to an amount of cooperating compensation, then this form can be used to document the amount of cooperating compensation that the listing firm will pay to the selling firm at closing. If the seller has not authorized cooperative compensation in their agency agreement, then this form can be used for the seller to enter into an agreement of compensation directly with the buyer's agent. So that would be the other option. Please note that this is not an invitation for the buyer agent to directly contact the seller. We don't want that. All communication from the buyer agent should go through the listing firm as required by the Code of Ethics. If both the seller and the listing firm agree to pay cooperating compensation to the buyer's agent in the same transaction, then both the seller and the listing firm can execute this form separately with the buyer's agent. Or the seller and the listing agent can adjust their agency agreement in conjunction with using this form. There is not one right way to document cooperating compensation. It's fully negotiable. So this form is one tool to be used. And then the standard form agency agreements will all be used with this form to document how compensation should be allocated. So agents need to consult with their clients, potentially lawyers, closing attorneys, whatever you need. And the North Carolina legal hotline is always available. And of course, you can always contact your broker, Kevin. So this is the cooperating compensation agreement. So the first three blanks, you're going to write the name of the seller, the names of the buyer, and then the property address. If you are preparing this before you have an offer, that's totally fine. You can just leave the buyer section blank for now and then fill it in once you know who the buyer is. So number one, we have the fee. You're going to only check one. That's a really big thing for us. We've been seeing a lot of agents checking two. So you're only going to check one of these boxes. Option one, you're going to fill in the percentage of the purchase price that the compensation will be, plus any other amount that will be due at closing. And then option two, you're going to fill in the blank with a flat fee dollar amount. And then option three will be any other arrangement, and you can write that out there. Number two covers payment of the fee. So the fee will be paid to the selling brokerage and it will be paid at closing unless otherwise agreed upon. Section 3 covers the term, effectiveness, and expiration. So the agreement is effective once signed by all parties and will terminate upon closing of the sale. If the fee has been earned before closing, the agreement will not terminate until either closing or termination. Section 4 is the merger, modification, assignment, enforcement, and governing law. So all parties agree to the terms of this agreement, and modifications can only be made in writing. This agreement can only be assigned by written consent, and if litigation ensues as a result of a disagreement, the winning party can obtain attorney's fees from the losing party. Now, I didn't include page 2, but page 2 is just the signature page. When you are in Dotloop, if you have a listing, the buy side might be presenting you with the cooperating compensation agreement. However, if you would like to add one to your listing and fill one out yourself, you can do that in Dotloop by clicking Add Document. Then you're going to click on Templates. You're going to click on North Carolina Residential Listing right here. Then you're going to check the box next to 220, and then you're going to click Copy, and it's going to add this document to your loop. All right, so now we are getting into the purchase or the listing agreement. So there have been some changes to the listing agreement, mostly relating to the broker compensation. So the language added makes it clear that compensation is fully negotiable, not set by law, and is determined by each broker and firm individually. There was language added to require the client's consent if compensation is offered that is more than agreed to by the client in the agency contract. So it should be noted that the answer no can be part of any negotiation. Any agent or firm is permitted to determine the value of their services as long as that value is not set, determined, coordinated, or in any way unlawfully affected by what a competitor might charge or is charging. So just a few notes here on the different parts of the contract that have been changed, and we're going to go over that right now. So this is page 1 of the listing agreement. This is agreement between the seller and Dalton Wade Inc. to sell your property. The firm is given the exclusive right to find a buyer for your property based on the terms of this agreement. If the property was previously owned by someone who has passed away, the documents like the tax listings or deeds might not accurately show you who should be listed as the seller. And so the will of the deceased person or North Carolina's laws for handling estates without a will should guide you on who is to sign this agreement. For properties owned by entities like corporations, LLCs, or trusts, the agreement should be signed by an authorized representative of that entity. All right, a term of agreement. So the agreement will start on the effective date, which is when both parties sign the contract, and end on the expiration date, which will be specified here. The effective date starts when both you and the firm sign, or if your property is already listed with another firm, it starts when that listing agreement ends. The expiration date is when the agreement ends, it'll be on a specific date. Section 2 covers the property, which refers to the property that's being sold. It includes everything related to the real estate, like the address and improvements, fixtures, and any personal property that's listed in the agreement. You're going to fill in the property details, and the agent and seller are going to initial at the bottom. Page 2, we have the legal description. So you're going to complete all applicable, and you can find all of this information on the county assessor's site. Please note that it's important to have detailed discussions and written descriptions in paragraph 3 and 4 of the offer to purchase and contract form. So this helps to minimize disputes with the buyers. The sellers and agent signing the agreement should discuss and specify what items the seller is willing to include in the sale, what items the seller wants to exclude, and any items on the property that the seller may not own. Section 3 is the fixtures and exclusions. So avoid assuming what items are included in the sale based on verbal statements. You need to be specific in the sales contract about what items are included and excluded. This will prevent misunderstandings and a lot of legal headache that some agents experience regarding this area. So fixtures will include all existing fixtures that are part of the sale unless specifically excluded. And the specified items are both buyer and seller will agree that certain items listed in the offer are included in the sale unless excluded. Before closing the sale, the seller must unpair any devices that will be included in the sale, delete personal data from those devices, and reset them to factory default. Any fixture or item mentioned in A and B that won't be part of the sale must be listed in D or E as appropriate. And number 4 covers personal property. So here will be listed any personal property at the time of the offer that will be transferred to the buyer. Section 5 is the home warranty. So the seller agrees or does not agree to provide and pay for a 1-year home warranty for the property with costs not exceeding a certain dollar amount. If the seller agrees, the firm will receive a fee for assisting with obtaining the warranty. Section 6 is the listing price. So the property is listed for a specific dollar amount under these terms: cash, FHA, VA, USDA conventional, loan assumption, seller financing, or other. The seller is open to selling at these listing prices or any other acceptable price or terms. Section 7 covers the firm's compensation. So the seller agrees to pay the firm a fee of a set percentage of the gross sales price or a set fee, which includes any compensation paid to other real estate firms. The fee is earned if the firm or another party finds a ready, willing, and able buyer at the listed price or acceptable terms during the agreement time. The property is sold, optioned, exchanged, or conveyed during the agreement term or within a protection period after expiration. The fee is due when proceeds are distributed at closing or if the seller fails to sell the property under the specified conditions. If the seller's entity is transferred, the fee is calculated based on the property's fair market value and the percentage of interest transferred. If the firm receives additional compensation from another party related to the property sale, the seller permits the firm to receive it along with the fee. The firm must disclose this to the seller before accepting an offer. Section 8 covers the cooperation and compensation to other firms. The firm has informed the seller about its policies on cooperation and compensation to other brokers. And the seller authorizes the firm to, here you will check all that apply, cooperate with subagents representing the seller and offer them a specific compensation with the buyer's agent representing the buyer and offer them specific compensation, and cooperate with and compensate other cooperating real estate firms as per the firm's policy. So the firm will inform the seller promptly if the compensation offered to another differs from the specified amounts, and agents from cooperating firms must disclose their relationship with the buyer to the firm verbally at first contact and confirm it in writing. Sellers must initial under this paragraph that they understand that compensation to cooperating brokers are not required. Section 9 covers the firm's duty. The firm will disclose the existence of offers on the property upon inquiries from buyers or cooperating real estate firms. with the seller's approval. If authorized by the seller, the firm will also disclose whether offers were obtained by the agent who signed the agreement, another firm agent, or a cooperating real estate firm. All right, firm's duties continued. The firm will use its knowledge and experience to market and sell the property. While they can't guarantee a sale, they'll make best efforts to find a ready, willing, and able buyer. The broker cannot disclose offer terms without the party's permission, and the firm must disclose all material facts about the property to potential buyers. The firm provides real estate services only. Other professionals like attorneys or inspectors may be needed, and the seller is responsible for their fees and quality of service. The firm may share this agreement with the listing services if required, and the seller agrees to this. So the notice at the top. So the agent and the firm will handle all brokerage activities related to this agreement without considering the race, color, religion, sex, national origin, handicapped, familial status, sexual orientation, or gender identity of any party or prospective party. And then a warning here, this is kind of important. Buyer letters to sellers can sometimes contain personal information. In fact, they often do. And this could unintentionally influence the seller's decision in a way that violates fair housing laws. Sellers should discuss with their firm how to handle these letters to avoid any legal issues or appearance of impropriety. The seller's initials must be under this paragraph. Section 10 covers the marketing. The firm is authorized to commence marketing on the property. As described below on the marketing date, the firm is obligated to present the seller any offers on the property that may be submitted to the firm prior to the marketing date. And check the public marketing or office exclusive. So public marketing, the firm will submit property information to the listing service it belongs to. And the authorization option. So you're going to check all that's applicable. Coming soon advertising, marketing the property as coming soon from the marketing date following the listing service rules, and signs, placing or removing signs where permitted, conducting open houses as agreed upon with the seller, advertising the property through non-internet media, and displaying property information on the internet directly or through listing services, as well as allowing other firms to do the same within listing service rules. This includes disclosing the property address, market value estimates, and third-party comments. Sellers can opt out of internet advertising if desired by completing an opt-out form. Office exclusive. So the seller does not allow the property to be publicly marketed, including on social media or other participants in the listing service that the firm belongs to. So the firm will be prohibited from public marketing of the property through any method listed in paragraph 10B. If the property needs to be publicly marketed later, the agreement must be amended according to NCR Standard Form 710. The property listing must be submitted to the listing service and shared with its participants within 1 business day of any public marketing of the property. All right, so lockbox and boxes. So you're going to check whether or not the seller authorizes the firm to place a lockbox on the property. And seller's acknowledgement. The seller understands that allowing access to and sharing information about the property carries risks beyond the firm's control. The seller is responsible for securing valuables and personal items, and the seller releases the firm and its agents from any claims not caused by the firm's negligence. A warning at the bottom is that it's illegal under federal and state laws to listen to or record an oral communication without the consent of the other party. So if there are video or audio surveillance devices, no audio should be active during the showing, open houses, or inspections. Section 11 covers earnest money. Dalton Wade does not hold earnest money, and so earnest money deposits must be held by an escrow agent named in the sales contract until the transaction is completed or terminated. Section 12 covers the seller representations. So ownership, the seller indicates how long they have owned the property, either for at least 1 year or less. They agree to provide information about their acquisition. Bankruptcy, the seller will disclose if they are currently under bankruptcy protection or considering it. And access confirms if the property has legal access to a public right-of-way through a private road or an easement. D is the manufactured mobile home. So if there's a mobile home on the property being sold, details about its VIN number and the description will be needed. E is the owner's association. This provides information about any HOA and the property, including the contact details. F covers disputes. The seller discloses any known disputes, violations, or legal issues involving themselves, the HOA, or the property. And foreign seller. If the seller indicates they are a foreign person, as defined by tax laws, necessary documentation will probably be required. The receipt of sample forms acknowledges receiving sample copies of important forms for review. And the flood hazard disclosure confirms if the property is in a designated flood hazard area and if flood insurance is maintained. Synthetic stucco. So this notes that if synthetic stucco has been used, and then K is the termite bond. This will indicate if there's a termite bond on the property, if it's transferable, the costs, and the details. And then current liens. This will provide information about any deeds of trust or mortgages on the property, including lender details and the balance if applicable. All right. Okay. So the seller payment status. The seller confirms if they are current on all payments and all loans mentioned in the items here. Section 3 is the loan default status. Section 4 are the liens and liens and taxes. 5 covers the judgments. 6 covers UCC fixture filings. 7 covers specific exceptions. And then M will cover the leases, if the property is subject to any leases. N covers the FHA appraisal, if there is one. O will cover the special assessments. And P will cover any fuel tank details. So if there's anything on the property, any fuel tanks, including their description, usage status, ownership, location, refilling schedule, etc. All right. So if there are any offsite and separate properties, so this indicates whether the sale of the property includes any offsite or separate components like a septic lot, boat slip, etc. There are government compliances. So the seller warrants that the property is not in violation of any laws, permits, or government regulations. And Section 13 covers the seller's duties. So providing accurate information here, the seller agrees to provide the firm with accurate and timely information. And a warning here that the seller understands if a lead-based paint disclosure is required but not given to the buyers prior to the seller's acceptance, the buyer may not be obligated to purchase the property. All right. Making the property available in B at the bottom. So the seller agrees to make the property available for showings at reasonable times upon reasonable notice. And the seller agrees to provide the firm with copies of various documents relating to the property. The seller agrees to immediately refer all inquiries or offers regarding the property to the firm, show the property only through appointments made through the firm, and conduct all negotiations through the brokerage firm. So seller's duties continued. So the seller agrees to execute and deliver a general warranty deed at settlement, conveying fee simple marketable title to the property. If any sale of the property may be a short sale, consideration should be given to attach NCAR Form 104 as an addendum. Section 14 covers the home inspection. The seller is advised to obtain a home inspection for the purpose of evaluating the condition of the property in order to enhance its marketability and help reduce concerns of prospective buyers. Section 14 covers paragraphs of materials. The firm is authorized to use all materials obtained or provided. And section 16, you'll list any additional terms and conditions. Section 17 covers dual agency. If a buyer already has an agent at your firm and wants to check out a property you're selling, this is when dual agency would come into play, which means that the firm is representing both the buyer and the seller. The seller must agree that if your firm acts as a dual agent, they can't share certain information without permission. If the firm is the agent for both the seller and the buyer, they must be fair to both sides regarding negotiations. And the firm might learn things during the process that could help or hurt either side. And so the brokerage has to be very careful not to share that information that could harm one side or the other. If the firm becomes a dual agent, the seller needs to make their own decision about the terms in the agreement. They also need to understand that the brokerage will aim for fair representation, which means they won't be favoring one side over the other. The seller must acknowledge that the firm will act as a dual agent, and they should weigh the benefits and drawbacks of this. By agreeing to dual agency, the seller gives up the right to make certain claims against the firm, except for violations of real estate law. In some cases, the brokerage firm may offer designated dual agency, where different agents represent the seller and the buyer within the same brokerage. Section 18 covers the termination or breach, mediation, attorney's fees. So the agreement is binding for the stated term. If the seller ends the agreement early without mutual consent or legal cause, it could be considered a breach. If either party breaks the agreement in any significant way, the other party can take legal action and seek legal fees from the losing party. If there is a disagreement related to this written agreement, the parties will try to resolve it first through mediation in good faith. We have a big warning here about wire fraud. So the agreement advises the seller on handling wire transfers for their proceeds at closing. It's recommended to provide wire instructions in writing, preferably in the presence of an attorney. To prevent fraud, it's crucial to verify that these instructions, to verify them over the phone, initiated by the attorney's office. The seller should use an independently obtained phone number for this contact, not relying on numbers from emails or from agents. Section 19 is the entire agreement. So this states that the document represents the complete agreement between the seller and the brokerage firm, containing all of the terms and conditions. If there are any changes, additions, or removals to be made, they must be in writing and signed by both the seller and the firm to be valid. And then everybody is going to sign. And that is all I have here today. So I will stop recording and open it up for any questions or concerns.